Denzale Lee, C371483.
Good morning, Your Honor, Courts of the State.
Good morning, Your Honor. Attorney Lance Andrew with Mr. Lee, who is present in custody.
Your Honor, I'm sorry to interrupt. Before we begin, I just want to update the court on something. We, as you know, filed a new superseding indictment last week. Mr. Brooks, my co-counsel on this case from the Court of Return Court, requested that the returns court issue warrants in the precise amount that this court set at the prior hearing. Unfortunately, that's not what happened. That returns court issued amounts from, I can't tell where, but different amounts. We reached out yesterday by email to this court and to the returns court. We included all defense counsel on it, asking the returns court to please amend those warrants immediately to reflect what Your Honor already imposed on those that you've decided to bail on. They've advised us that we need to bring it up with you.
Okay.
So I'm raising it now just so that the court's aware. If the court wants to sua sponte amend those warrants to the amount that you set, I have no objection, and I'm sure the defense counsel doesn't either.
Okay, so it looks like on this matter, I had previously addressed Queen, Washington.
Yes.
Which one is Ms. Brown's client? Because I did not address that one.
Mr. Robert.
Okay, I did not address Roberts. I did address Jackson and McDuffie and Lee. We had stayed the same from previous, which was $250 with house arrest.
Correct. And
So-
we're addressing Mr. Lee today.
Exactly. So we're going to have Queen, Washington, Jackson, and McDuffie should have gone back to the amounts that I set them at. There was an error because ultimately the minutes had not been updated for Judge Reese to see what those amounts were, so he went back to what he believed them to be, which was an error. And so I'm saying on the record that nothing should have changed, and I did actually view the video of you guys in grand jury, and it did say you were asking to transfer. So you didn't do anything incorrect either, it's just a misunderstanding, and so, yes.
Yeah, the case that keeps giving for me, apparently, Your Honor.
It's okay. All right.
I apologize again for the confusion, but I'm glad we're able to get that resolved.
Okay, so at this point, we had already heard argument from Mr. Hendren and from you regarding bail. At this point, bail had been, bail was $250 with house arrest, and then the Queensridge incident was added for Mr. Lee. What are you seeking today, Mr.
So
Brooks?
we would
I was
request,
going to say Brooks, but I know that's wrong.
we would request that the court impose the same bail setting that was set for Mr. Washington, which is $600,000 with electronic monitoring, no contact with the co-conspirators or co-defendants, is charged in the same facts and counts. And I can tell you that, well, beyond what we've already argued, I do want to make one point of clarification, because I know when I was discussing Mr. Lee the first time, I had indicated on the day of the Queensridge event that they left a resort that they'd been staying at wearing the same clothing that the victims described. So just so I'm being clear on the record, that was inaccurate. They checked out that morning wearing casual clothing. They are then seen immediately after the Queensridge event fleeing to California, where we presented a video of Barstow, a Barstow gas station that shows the court. The defendant, Mr. Lee, is with Miss Queen and Mr. Butler, and he is in the dress that the victims described him in, and the video is very clear, showing black hoodie, white Nike logo, and similar identical clothing that he's wearing in the other home video that's the earlier levels.
And so regarding the Queensridge video, he is in those clothes in the house, outside of the house. Where is he at?
There is no video from inside the house. The victim described the suspects as all wearing black hoodies.
Okay.
And one wearing a dark blue hoodie, which would be Mr. Butler.
Okay.
That was consistent with what we saw at the video of them immediately after the Queensridge flew back to California, and wearing that same clothing. And then again, I just reiterate, he was on this text thread link on their way back from California to Las Vegas prior to their arrest, where defendant Queen is sending a video of another house for them to target, discussing homes and discussing where the cameras are and how they can approach and hack that particular house.
Okay. Thank you, Mr. Quartz. Turning to you, Mr. Hendren.
Yes, Your Honor. Thank you. And I know we're back here today. We're also going to have to address the third superseding indictment with the additional charges against Mr. Lee. This whole indictment process has been somewhat of a tortured process, going back and forth. But what I would at least like to highlight for Your Honor's consideration was that back when the case was originally indicted back on February 10th, according to those court minutes, the allegations of Mr. Lee was even brought up at that point in time regarding the new allegations that he's charged with, which has now been over a month, if I'm not mistaken. And so I think where at least I have concern is the bail then is transferred on this date from Henderson Justice Court to District Court because the case has now been indicted. And the facts are made known about this additional home invasion that Mr. Lee is alleged to have been involved with. That really has never changed over the course of the last month, at least the state's position. It was at least uncertain based on some of the procedural posture, what was going on, because the case against Mr. Lee was originally indicted at the superseding indictment, but then subsequently those counts were dismissed at the second superseding, and now we're back here again on the third superseding that has Mr. Lee charged with these offenses yet again. So it really just comes down to, Your Honor, I don't know what has necessarily changed other than the state coming back yet again to file formal charges against Mr. Lee. But as far as what actually changed over the last 30 months, aside from that, all this information had been known even at the time that Mr. Lee was indicted. So I would ask that Your Honor keep the bail at $250,000 cash or surety, and then we would also be amenable to the level 4 PSU. The only issue with that's going to be if we leave it at $250, and this would simply be a record that I would make, is that Mr. Lee is not financially capable of posting that amount. So in essence, where the current bail setting at is in essence a detention order, which is why we filed the bail motion for reconsideration in light of the fact that the bail schedule, once Your Honor clarified that with me, and I appreciate that, when it was set at $19,000 at the time of the arrest. So in light of the fact of his indigency, we would ask that that bail return to that amount. Otherwise, it's a per se detention order because he wouldn't be able to afford the current setting. Yet also including the level 4 PSU monitoring, all these new devices that pretrial has coordinated to assure safety to the community and that the defendant will appear.
All right.
That would be my request, Judge.
Thank you, Mr. Hendren. We had $250,000 bail set by the Justice of the Peace. Obviously, that transfers. Additionally, though, there has been this Queensridge charge, which has been added. Of the series, this is obviously the most violent, the most concerning of the offenses that these defendants are charged with. A woman was drowned in a bathtub in her own home. An elderly man was struck about the head, and it still has lingering health effects from it. And there was additional planning of this crew to continue victimizing additional residences. So the Queensridge incident is something that's very concerning to this court, and it was something that I addressed when I added, set the bail for Mr. Washington. I think considering Mr. Lee's background and everything, and the facts of this case, there are no non-monetary conditions that can just keep the community safe. And at this point, what I'm going to do is set bail commensurate with Mr. Washington of $600,000 with high-level electronic monitoring. Obviously, if there's any change in the sufficiency of this or anything, once we see these grand jury indictments and there's writs, I will readdress these bails if there are changes in the charges.
So we had him at level 4 PCU.
He's at level 4 PCU, not high level. Okay, so that'll be level 4 PCU because I believe he does not have ties, which would make high-level electronic monitoring possible. So. But it is meant to be a detention order anyway, so that's somewhat academic.
And then I know it's kind of perfunctory at this point, but no contact with the victim.
No contact with no contact with co-defendants, no contact with victims.
And this is cash or surety?
Cash or surety.
Okay.
Thank you.
Thank you.
Page 2.
We also, don't we have to?
I'm sorry, yeah, I believe the arraignment is scheduled for.
We are going to keep the arraignment for 3/22 and do everybody at the same time because then maybe we can address trial dates at that time.
Got it. Okay.
Thanks, Mr. Hendren. We'll see.